don't have a lot of time, and I know everyone has spent a great deal of attention on everything that's happened at this wonderful conference, and being in the 7th panel is a very challenging place to be. Judge Song, former President Song, said, well, now we're going to hear the final verdict, and appropriately enough, we at least have two judges here, so we can get a majority verdict. But the subject of our panel deals with the ongoing impact of the Tokyo trials, and its impact particularly on the modern era, on the post-Cold War tribunals that have been established, that have carried on very much the project of Nuremberg and Tokyo. I'm not a speaker here, but let me just say a few things preliminarily from my own perspective as a person who is a prosecutor in two post-Cold War tribunals, chief of prosecutions at the Rwanda Tribunal and then chief prosecutor at the Sierra Leone Special Court. And other colleagues of mine, Serge Brammertz and Brenda Hollis, David Tolbert, were part of the advisory board of the Nuremberg Academy are here as well. But I think all of us who've been called to these courts in the role as prosecutors really do see ourselves as part of this project of international criminal justice that began at Nuremberg and Tokyo. Frankly, our knowledge of Tokyo is not as great as that of Nuremberg. Those of us involved in this have met every year now for the last 11 years, at least the former chief prosecutors in Western New York every August at Chautauqua and also at the Jackson Center. And we had one of those sessions here at Nuremberg to commemorate the 70th anniversary, exactly on the day of the judgment of the IMT. And certainly we felt ourselves very much part of what happened there, and constantly we're drawing and even inviting the contributions of those that survived and that were involved in that process. But I think we also recognize how much we owe to Tokyo and how much this is really all part of the same thing and in certain essential respects. And one of those is the idea that high-level individuals should be held to trial. As Don Ferenz was quoting Jackson, the common sense of mankind requiring that the law not stop with the punishment of little crimes by little people, but that must reach men who possess themselves with great power and make deliberate use of that power to set in motion evils which touch every home in the world. And the idea that one needs to focus not just on the direct perpetrators, and there were prosecutions in the past and military commissions and courts-martial of direct perpetrators, but you need to focus on the authors of these crimes, the persons who made the decisions, who conscripted others to do that, or incited others to do that dirty work. And that's very much a legacy that's being carried on at the International Criminal Tribunals since the end of the Cold War. We also, I think, have learned here, to a greater extent than I knew, that at Tokyo we see the expansion of the idea of superior responsibility to include civilians, and that was so important. I see the president of that, the former president of the ICTR, and the presiding judge in the media trial, where in the end we were able to convict Nahimana on civilian command responsibility, on essentially having effective control of that radio station at the time that these inciting broadcasts were made, and thus was prosecuted and convicted for incitement to genocide. And so that is something I think that we owe to Tokyo as well. I would also note that to some extent what we do in the tribunals also represents an effort to learn from the criticism. And one aspect of that is certainly the ways in which we confront the criticism of victor's justice, and we've talked a lot about that. But I know certainly at the ICTY and at the Special Court for Sierra Leone, we constantly focused on trying to make sure that we were prosecuting at least organized and significant war crimes committed on all sides. And certainly that happened in the former Yugoslavia tribunal. It happened in the Sierra Leone, where we prosecuted very powerful men who were in charge of a pro-government militia. And the failure to do that at the ICTR is one of the enduring criticisms, frankly, of the Rwanda tribunal. So that's a lesson we've learned. The other thing, and it'll, I think, perhaps come up in Professor Koh's discussion, goes to the sort of principle of legality. And of course, the criticisms of the ad hoc tribunals and their creation by the Security Council, but with the creation of the ICC, we have a treaty-based court in which countries are only held responsible, their citizens are only held responsible for crimes, the elements of which and the essential substance of which they have approved through the prior ratification and adoption of the Rome Statute. And the whole principle of legality, I know, was extremely important to the Japanese. I don't want to get involved in a discussion on the crime of aggression, but we remember, and I was in Kampala in 2010, where after agreement was finally reached on a consensus resolution, when Britain and France finally agreed to it, and it was being passed at midnight on the last night, the Japanese delegate spoke, and for a moment almost appeared that Japan would break consensus, but it went to the issue of the language being unclear about what countries this would apply to. And the issue, frankly, it was debated again in New York in December when we actually finally had activation, whether a country would affirmatively have to approve the language before it could actually affect its citizens. And having discussed that issue, Japan circulated a non-paper on that issue. I later talked to Deputy Foreign Minister Nagamine about it. Frankly, that was a reflection of the continued feeling that it had been unfair at Tokyo to prosecute Japan based upon Kellogg-Briand. You needed to have a criminal statute and need to be explicitly such. Obviously, that particular problem is cured, I think, in the way that this issue was approached in New York and the ways in which the Rome Statute has been ratified to date. People will only be prosecuted for crimes, their citizens will only be prosecuted for crimes that they've approved, with the exception, of course, of the possibility that the Security Council, representing all of the countries of the United Nations, could send a case to the ICC. So we really do have, I think, a profound impact from Tokyo on the modern project. But to discuss this matter today, as I said, we have two judges, Judge Liu, a judge of the International Criminal Tribunal for the former Yugoslavia, of course, that's now formally closed. Now its work being carried on by the mechanism of the International Criminal Tribunals. He's on the Mladic case, probably the Mladic appeal, probably the last business of that MICT, at least as it comes from cases from the area of the former Yugoslavia. He's also been a member of the Court of Permanent Arbitration, Permanent Court of Arbitration in The Hague, a diplomat for China in the past, and deputy director for treaty and legal affairs in their Ministry of Foreign Affairs. I think he said he needs 10 minutes to speak. I know better than to put a timer on a judge, but anyway, it's your turn, Your Honor.
Thank you, Mr. Ambassador. First of all, let me join others in thanking the International Academy of Nuremberg Principle for inviting me to this, august gathering together. And as all you know, that on the 27th November 2017, the appeals chamber of the ICTY delivered judgment on the Perlich case, thus finishing the judicial practice which lasted for 24 years already. On December 21st, 2017, the ICTY held a grand closing ceremony in the center of the Hague. The King of the Netherlands, the Secretary General of the United Nations, attended the ceremony. The Secretary General of the United Nations stated, I quote, "The International Criminal Tribunal for former Yugoslavia has been a pioneer in creating the contemporary architecture of international criminal justice. The creation of this tribunal demonstrated a newfound and serious commitment by international community that those responsible for perpetrating the most serious crimes of international concern should be held accountable for their actions. It is admitted that, in my view, the ICTY up to now is the most successful and effective international criminal tribunals in history. The ICTY indicted 161 accused, and all of them has been located or found out, and most of them have put on trial and convicted, which sent a very, very strong signal to the international community that, the ignorance will no longer be tolerant. UN headquartered tribunals as a whole, including ICTY and ICTR, had inherited and developed the jurisprudence of the Nuremberg and the Tokyo tribunals. The Tokyo Military Tribunal, established, as we all know, in 1946, lasted about 3 years, and with 28 defendants indicted, among them 25 convicted. The jurisprudence of the Tokyo trial is consistent with the reasonings of the Nuremberg trials. The legacy of the Tokyo trial constitutes a landmark in the development of international criminal law and international humanitarian law after World War II, and set a brilliant precedent for the ad hoc tribunals and the United Nations Security Council to address the individual criminal responsibilities. It is not very difficult to observe that the impact of the Tokyo trial to the ad hoc tribunals are everywhere, from the substantive law to the procedure law, on the specific ingredients of a crime and on the mode of the liabilities. For instance, the rape and the sexual assault and the war crime, superior responsibility of the civilian leaders, rights of the self-representation, right of appeal, which has been covered by the previous speakers in the past 2 days. I want to mention here specifically that in the practice of the ICTR, in the Accession case, the Nuremberg Trials judgment was specifically quoted to prove that the superior responsibility for the civilian leaders has already been a rules of the customary international law. And I prepared a very long, article, but before the conference, I was advised that, I'm the last but one speakers. So all the issues has been covered by previous speakers already. So I'm just talking about the 2 issues. One is the common plan and conspiracy, and the other is about the immunity of the head of the states. It is true that the Tokyo trial made no findings on the crimes against humanity. Instead, it concentrated on the charge of the crime against peace and the war crime. Moreover, as some speakers all mentioned, that the conspiracy in waging aggressive war was the heart of the prosecution's case, charging related to the common plan or conspiracy in committing crimes against the peace. In the Tokyo trials, among all those, indictees, 8 defendants are civilians who were not the physical perpetrators of any specific crimes on that, which means that they are not, in the fields to killing the people, to burn the houses, and to commit those war crimes in the fields. And in the Nuremberg judgment, only 8 out of 22 defendants were found guilty of conspiracy, and none were so convicted without also finding a guilt as to the substantive offenses of the crime against the peace. This may lead to the conclusion that conspiracy was a mode of the liability rather than an inchoate crime. In the Tokyo trial, the prosecutor of the United States, Mr. Keenan, in his opening statement, make it very, very clear that he said that, I quote, "A conspiracy is a combination of the two or more persons by concerted actions to accomplish a criminal or unlawful purpose, or some purpose not in itself criminal or unlawful. By criminal or unlawful means, it is a partnership in criminal purpose. The gist of this crime is a combination of the minds." But however, the Tokyo judgment is not very clear on that. It did not discuss in details about the nature of the conspiracy, but it just defined the conspiracy as arising when two or more persons entered into agreement to commit a crime. As it mentioned before, that one of the problems of the Tokyo judgment is that it spent so much pages on the factual issues and leave very little for the discussions of the ingredients of the specific law and the mode of the liabilities on this aspect. So one possible interpretation of the Tokyo judgment is that a conspiracy could be regarded as a substantive contribution to the common criminal plan or desire. That is the mode of the liability. The other interpretation is that conspiracy is an inchoate crime which does not require the underlying crime really occurred. It punishes the common desire of a crime. Let us look at the practice of the ad hoc tribunal's practice. Based on the jurisprudence of the Tokyo trial, the ICTY developed the concept of the conspiracy into two legal concepts. One is the joint criminal enterprise. The other is that is the mode of the liability. Another one is the conspiracy, that is inchoate crime. For the joint criminal enterprise, it requires that it needs the plurality of the persons, not necessarily organized, a common plan, desire, or purpose involving the commission of a crime prescribed in the statute. The participation of the accused in the common plan and desire to perpetrate a crime under the statute. A shared intent between all the participants to further the common plan or desire involving the commission of the crime. That person, even if not personally affecting the crime, but he intended that result. As for the conspiracy, in my view, the judicial practice of the ICTR is more opulent than that of the ICTY. In that case, the ICTR trial chamber said that the conspiracy is an inchoate crime, and such as has continuing nature that culminated in the commission of the acts contemplated by the conspiracy. In another case, the trial chamber also said that act of conspiracy itself is punishable, even if the substantive offense has not been actually been perpetrated. So there may be a question of the double convictions, First of all, I would like to say that, from the jurisprudence of the Tokyo Tribunal, as well as from the ad hoc tribunals, the conspiracy, that is the inchoate crime, only applied to most serious crimes. For instance, in the Tokyo trials, it's only applied to crimes against the peace. In the ICTY and ICTR's jurisprudence, it's only applied to the genocide. There's no cases, for conspiracy to be applicable to other forms of the crimes. Accused could be convicted for both genocide and conspiracy according to the jurisprudence of the ICTR, since the crime of genocide does not punish the agreement to commit the genocide on that. Next issue, I'm talking about the immunity of the head of the states. After World War II, there were widespread demands that Japanese emperor be prosecuted, and the evidence showed that he was personally involved in aggression war and some other crimes. However, he was shielded from the prosecution and the trials, freed from the prosecution and the trials by the order of the Supreme Commander, General Douglas MacArthur. The immunity was not limited to the emperor himself, but also extended to the members of the royal family. I'll give you an example. For instance, the Principal Asaka's case. He's a member of the imperial family. Prince Asaka was the commander of the Japanese force in the final attack in Nanjing. He allegedly issued the order to kill all captives, but he was not prosecuted by the IMTFE. An extradition request by the Chinese authority for trial in China was also refused. After war, Prince Asaka spent most of his time playing golf. He died of the natural causes in 1981 at his home at the age of 93. I think this is a big problem, for the immunity of the head of the states. And the ad hoc tribunals tried in its practice to correct these mistakes. So it's completely changed the situation with an aim to end the immunity. Many of the head of the states and the government were indicted by international criminal tribunals. For instance, in our case, in the ICTY, Milosevic was the president of Serbia, Karadzic as the president of the Republic of Srpska. I hope you could understand this phrase, this country. And Mrs. Placevic was the Serbian representative to the presidency of the Bosnia and Herzegovina. In the case of the ICTR, Kabanda, he was the prime minister and head of the government of Rwanda during the period of the genocide. In the Sierra Leone Tribunal, Charles Taylor is the president of Liberia, and he was convicted for 50 years of the aiding and abetting crimes. And also, the recent example is the ICC. Omar Bashir, he's the sitting president of Sudan. So the whole picture, is changed. Although there are some criticism on the Tokyo trial, and I believe that it is not fair to use the present standard to judging what happened 70 years ago. The practice of the Tokyo trial set a very good example, for the conducting of the international trials for the later international criminal tribunals. The Tokyo trial and ad hoc tribunals, sent a very strong and powerful message to international community, especially to the Asian countries, that impunity is no longer allowed. The state in Asia should claim regional ownership, to the Tokyo trial. The states in the Asian region must not only to get the message from the Tokyo trial and the ad hoc tribunals, but also have the full access to the records and absorb their jurisprudence into their national legal systems and the judicial practice. The lessons learned and the practice identified will provide valuable experience, especially to the Asian states. Thank you very much.
Thank you very much, Judge Liu, and I really appreciate your discussion of the issue of conspiracy, particularly at the ICTR, because to be frank, at the end of the day, it was challenging to win convictions for conspiracy. We had one in the media trial, but it was set aside with about 3 sentences on appeal, and I think the only conspiracies to genocide that were in the end sustained were those that were very narrow, such as in Nieta Geka, where he was involved in planning the killings in the Bisesero Hills. So it was on the books, but it was a difficult thing to win on, and I think to some extent reflected judges from other traditions who weren't familiar with it in their law. And of course, we'll now go to the ICC, where the conspiracy to commit genocide, which is part of the Genocide Convention, was left out of the Rome Statute. So we will not have conspiracy cases at all at the International Criminal Court. But to talk about the impact of Tokyo on the ICC and its jurisprudence, we have a judge now for almost 9 years of the International Criminal Court, Judge Osaki. I think I got to know her before she even joined the court, when she was the head of treaty affairs at the UNODC, and she's served now, I think, on several of the most important judgments, including the Kenya case, which obviously didn't result in convictions, but the Bemba case as well, where she was part of a trial chamber that convicted a former vice president, and now sits on the Antaganda case, which is in trial, and her term is extended till the completion of that case. We're very happy to have you here today, and so it's your turn now, Judge Osaki. And I think you said 15 minutes, so I think we've got that. Take it.
Thank you very much, Ambassador Rapp, for your kind words. And I would also like to thank Nuremberg Academy for the invitation to this conference. I would also like to make the usual disclaimer that the entirety of my presentation at this conference is of a personal nature and does not represent the views of any organizations that I belong to. My contribution today will look at the influence of the Tokyo trial on ICC, or more accurately, the lessons learned from Tokyo trial from the perspective of the ICC, including via two UN ad hoc tribunals, ICTY and ICTR. As our distinct chair pointed out at the outset, the two IMTs, the two UN ad hoc tribunals and the ICC share the same goal of punishing the perpetrators of the most serious crimes, focusing on the individual criminal responsibility of political and military leaders. And crimes under their respective jurisdictions are of large-scale, systematic, and complex nature committed by multiple perpetrators. And all these features pose unprecedented challenges in international law, as well as procedure and substantive criminal law. It is in this regard that the two IMTs have been pioneers to ICC. The starting point for looking at the lessons learned from the two IMTs is the basis for the establishment of the court and its jurisdiction. Both IMTs were established by the Allied powers, with some variations, of course, while the ad hoc tribunals were created by the Security Council under Chapter 7 of the UN Charter. On the other hand, as stressed by, I think it was Mr. Pace yesterday, and also by our chairman today, the ICC is a treaty-based body aiming at being a permanent and universal criminal court. The founders of the ICC have thus tried to avoid the criticism brought to its predecessor tribunals as being victor's court or courts imposed by an outside body. While this contributed to the legitimacy of the ICC as an independent and impartial court, it inevitably brought ICC's fatal weaknesses as well. Instead of having powerful countries or an organization backing it, the ICC lacks enforcement power and is therefore completely dependent on the political goodwill of the individual member states at all stages of the proceedings. Currently, ICC is facing serious challenges such as lack of universality due to the failure of a significant number of states to join the Rome Statute, and suffers from criticism that the court is targeting a specific region. Lack of international cooperation in investigation and prosecution is also a big issue, and it is to be seen how and when the ICC will overcome these difficulties while keeping its unique legitimacy. The experience of the International Criminal Tribunals has also shown that there are two major issues which require particular attention in order for any tribunal to achieve its objective of delivering justice. One is procedural fairness. The other is respect for the principles of legality and individual culpability. I will now address how the ICC has learned its lessons in relation to these matters from other tribunals, in particular from Tokyo Tribunal. The procedural law of the two IMTs were based on military law or mixture of common law and military law, which may share some features with the procedural systems adopted at the ad hoc tribunals and the ICC, such as flexibility of evidential rules in order to be able to deal with complex crimes in an efficient and expeditious way. However, it has been pointed out by several panelists as well that the Tokyo Tribunal's rules of procedure and evidence, as well as their application, contained a number of shortcomings, mainly in relation to the right to cross-examination and the equality of arms, both of which constitute core values of the common law procedure. Those shortcomings arguably influenced the drafters of the ad hoc tribunal's founding instruments. But more decisive were, of course, the development of international human rights law and the adoption of the International Covenant on Civil and Political Rights. And the Article 9, the provisions in Article 9 have been reflected in the Statute of Ad hoc Tribunals as well as in Article 67 of the Roma Statute. The two ad hoc tribunals adopted procedures closer to common law system, leaving out the military law influence. However, as I mentioned before, the specific characteristics of the crimes under their jurisdiction have led to the way to more flexible procedures, for example, by allowing more documentary evidence than under traditional common law systems. The ICC, on the other hand, while firmly upholding the most recent human rights standards, embarked on an ambitious task of establishing a hybrid type of procedure belonging to neither the common law nor the civil law systems. This is mainly because not only the court statute, but also its rules of procedure and evidence were negotiated and adopted by state parties with different legal traditions, and they could not agree on many of the crucial procedural issues. Thus, much was left for the trial chambers to decide on case-by-case basis to find the best mix which enables the court to effectively deal with the crimes under our jurisdiction. However, again, as one can easily imagine, this is not an easy job for judges, and the endeavor is still ongoing. In terms of substantive law, the recent activation of the crime of aggression under the jurisdiction of the ICC has opened the possibility that the Tokyo jurisprudence may have an impact on the court jurisprudence. But as for the constituent elements of this crime, much has been already said during this seminar. Moreover, the ICC has not yet had any concrete case before it dealing with this crime. Therefore, I will limit my intervention to other aspects of substantive law where the Tokyo jurisprudence has already had a certain influence on our jurisprudence. One is broad interpretation of individual criminal responsibility, and the other is command responsibility, which is, of course, very closely connected with each other. As mentioned by Judge Liu, in pursuing the individual criminal responsibility of the accused for crimes against peace, Tokyo Tribunal developed a broad interpretation of participation in a common plan or conspiracy, including the criminal liability of those who shape the policy and influence. The Roma Statute took a more restrictive approach as far as the crimes of aggression is concerned in Article 25(3) bis. You can see you can read the provision. However, the broad interpretation of liability had an influence beyond the scope of crime against peace. All subsequent tribunals have faced challenges as to how to attach proper liability to those leaders and commanders, while strictly adhering to the principle of personal culpability. These developments have also been influenced by the methodology employed in some common law countries to fight against organized crime and terrorism, some of which have been accepted by UN conventions against organized crime or terrorism. And as Judge Liu again mentioned, the ad hoc tribunals have adopted and developed the concept of joint criminal enterprise, but not without criticism, to be honest. Article 25(3)(a) of the Roma Statute attached criminal liability again to a person who, I quote, commits such a crime whether as an individual, jointly with another, or through another person, regardless of whether that other person is criminally responsible. End of quote. The Lubanga appeal judgment endorsed the trial chamber's interpretation of co-perpetration, that, I quote, there was an agreement or common plan between the accused and at least one other co-perpetrator that, once implemented, will result in the commission of the relevant crime in the ordinary course of event. And that again I quote, the accused provided an essential contribution to the common plan that resulted in the commission of the relevant crimes, thus applying the so-called control over the crime theory. Moreover, in addition, several pretrial chamber decisions have adopted the concept of indirect co-perpetration based on the same provision, but with a strong dissent. And it is to be seen how the concept of co-perpetration will develop in the future. And of course, there is also a Article 25(3)(d), which also contains a very similar type of liability to joint criminal enterprise. Tokyo Tribunal's jurisprudence has been particularly influential in relation to command responsibility, as mentioned by some previous speakers. The Tokyo Tribunal basically followed the Yamashita, and not only military but also civilian political leaders. And it was further followed by the ad hoc tribunals, which developed extensive jurisprudence in command responsibility. Article 28 of the Roma Statute provides for command responsibility in a slightly different wording from the formulation adopted by the ad hoc tribunals. The first case at the ICC, in which an accused was convicted on the basis of command responsibilities, was the Bemba case. And the trial chamber in that case referred to the Tokyo jurisprudence, albeit only to the extent that it had been referred to the ICTY judgment that the trial chamber relied on. The standard set out in Article 28 is largely in line with the one set out by Yamashita and Tokyo, but it's formulated in a more elaborate and clear language in order to comply with the principles of legality and culpability. Furthermore, the evidentiary threshold required by the trial chamber in the Bemba case for proof of each of the elements, such as effective control, should have known standard, or measures within his power, is also higher than the one required by the Tokyo or in Yamashita. The jurisprudence in relation to command responsibility in ICC is far from ripe. Most importantly, the causality requirement which the trial chamber adopted between the crimes committed and the lack of proper control in the chapeau of Article 28, and which has not been discussed in ad hoc tribunals, is currently firstly litigated before the appeal chamber. And I received the news yesterday that the appeal chamber will deliver its judgment on 8th of June. So let's see. As a kind of conclusion, as I said at the outset, the ICC has much in common with the Tokyo in its efforts towards establishing individual criminal responsibility of those who are most responsible for large-scale, complex, and organized atrocities. And this constitutes an inherently difficult, if not impossible task. Moreover, for any international criminal court to be truly effective, following requirements should be put in place. 1, legitimacy and integrity of the court. 2, procedural guarantees of fair trial rights. 3, substantive law based on the principles of legality and individual culpability. I see shortcomings of the Tokyo in this respect, but at the same time, I can hardly say that the ICC has already succeeded in this task. There are so many challenges and obstacles that still need to be overcome. Challenges posed by Tokyo, it's in a sense quite contemporary in this sense. I tried to sketch out some of them, although it is, of course, beyond my capacity to clearly indicate where we should go. Hopefully, we are headed in the right direction. Maybe we are not. I thank you very much for your attention and look forward to the discussion. Thank you.
Thank you very much, Judge, for that very thoughtful and careful analysis of these legal issues. I really appreciate your participation today in this conference. Our final speaker of the conference, no, it's not. We still have Professor Safferling. We have a couple others, but the final panelist in our 7th panel is Professor Ko, who's a professor of law at Nanzan University. She's someone who has worked with the government of Japan, specifically as after the ratification of the ICC in 2007. She was part of a legal advisor to the working group on the crime of aggression in 2007 to 2009. She now serves, I think just recently has joined the treaty body for the Convention for the Elimination of Racial Discrimination in Geneva. So great to have her here today, and she'll be speaking specifically on the Japanese accession to the Rome Statute and the Tokyo Tribunal.
Very much, Ambassador Rapp, for your kind introduction. I am also grateful to the Nuremberg Academy and the organizers. I am honored to be here today to participate in this important conference. This panel concerns the legacy of the Tokyo Tribunal on the contemporary international criminal jurisdictions. I am assigned to taking stocks of the development in Japan, and for the next 10 or 15 minutes, I would like to explain the Japanese accession to the ICC, International Criminal Court. And by the way, I have worked with the government, but today all the views expressed are personal. Japan deposited an instrument of accession with the International Criminal Court on July 17, 2007, almost 10 years after the adoption of the Rome Statute. The Japanese Diet approved a bill providing for accession to the Rome Statute and corresponding implementing legislation known as the Act on Cooperation with the ICC unanimously. This does not imply that accession to or ratification of the Rome Statute did not raise any legal issues in Japan. On the contrary, the Japanese government spent as much as 9 years to prepare for the successful approval from the Diet. In 2007, then Minister of Foreign Affairs, Taro Aso, put forth 4 reasons for why it took 9 years for Japan. First, he said, it was necessary to verify compatibility between the crimes covered by the Rome Statute and the Japanese municipal criminal law. Second, it was necessary to enact new legislation that would prescribe rules for the cooperation. Third, it was necessary to conduct research into the responses and practices of other countries. Fourth, it was necessary to take appropriate budgetary measures in respect of contribution to be made to the ICC. Actually, this is very serious issue in a practical sense because Japan contribute about 28 million US dollars per year almost. But today I do not go any further about the budget. Well, the reasons put forward by the Japanese government for the 9 years delay are primarily linked to the examination of the necessity of enacting implementing legislation. However, this may not be very persuasive in the light of the fact that Roma Statute itself does not explicitly impose any obligation to pass new laws, except for the rules regarding the cooperation. Indeed, in the end, the government decided not to enact any substantive law and only propose a bill on the cooperation with the ICC. So, what were they doing these 9 years? In order to understand the Japanese position, one may need to explore the question of yuji hosei. The rules normally belong to law of armed conflict, or in other words, international humanitarian law, fall under the rubric of yuji hosei. Yuji hosei literally means the legal system applicable to times when something occurs, and is commonly understood to be any legal system applicable to extreme emergencies, such as that which is to be invoked in case of an armed attack. After the Second World War, any attempt to provide the Japanese legal system with the rules of yuji hosei was not possible. Underlying reason for this legal situation is Article 9 of the Japanese Constitution. Perhaps most of you know, but I just read it for you. Aspiring sincerely to an international peace based on justice and order, the Japanese people forever renounce war as a sovereign right of the nation and the threat or use of force as means of settling international disputes. In order to accomplish the aim of the preceding paragraph, land, sea, and air forces, as well as other war potential, will never be maintained. The right of belligerency of the state will not be recognized. This article, the renunciation of war and the denial of the right of belligerency, prevented Japan from enacting any legislation relating to war. In other words, in order to prevent the Japanese self-defense force from participating in belligerent activities, no legislation was supposed to be adopted that in any way was linked to the phenomenon of war. This sensitivity toward legal rules relating to war also applied to international norms. So, when the Roma Statute was adopted in 1998, Japan had not yet ratified the Genocide Convention, nor ratified the additional protocols for the Geneva Conventions, nor had any specific legislation governing crimes against humanity. In short, when the Roma Statute was adopted, the Japanese legal system did not have any legal institution or rules for punishing the violations of international humanitarian law. This was a serious deficiency for accession, particularly in light of the principle of complementarity of the ICC. However, the legal situation of Japan regarding the IHL was gradually changed after the end of the Cold War, and under Koizumi administration, the turning point came. In 2003, so-called Armed Attack Situation Law was enacted. This law serves the basic law in case of an armed attack against Japan and provides fundamental principles regarding measures to be taken by the government and the local public entities. What is important of this law for the purpose of my presentation is that its Article 21, Paragraph 2 provides that, I quote, necessary enactment of the law regarding the armed attack situation shall be compatible with the effective implementation of international humanitarian law applicable to international armed conflicts. End of the quote. Then, as soon as next year, in 2004, the implementing legislation for the Geneva Conventions and the ratification of the additional protocols were adopted in the Diet. In this way, the peculiar legal situation of Japan as regards to the IHL was substantially resolved and opened the door to the accession to the ICC. However, they spent another 3 years before submitting the accession bill to the Diet. And during that time, they meticulously examined the legal issues, particularly whether new legislation on substantive criminal law is needed. In the end, they came to the conclusion, the following conclusion. Most of these crimes are already punishable under current Japanese laws, as they can be treated as homicides, assaults, or cases of unlawful capture of confinement. It is true, theoretically, there are cases where current Japanese laws do not provide for any punishment, but such cases correspond to very minor acts, such as that which is set forth in Article 6D of the Rome Statute. It is also important to recognize that ICC exercises its jurisdiction only when the offense is of sufficient gravity, which, according to the practice of the ICC, would conform to the killing of a large number of victims. Thus, even if there is theoretically a case in which Japanese law does not prescribe a punishment, it would unlikely raise any real-world jurisdictional issues. During the debate in the Diet, at the committee, at the two houses, and the plenary meetings, a variety of issues were raised by the members of the Diet, such as whether the Japanese minimalist position is compatible with the principle legality provided in the Japanese Constitution, or whether any amendment is possible at the review conference, which was foreseen in 4 years later then, including a ban on the nuclear weapons. What effect would Japanese accession have on the relationship with the US, particularly on the security agreement? Would the ICC help to rescue the Japanese abductees in North Korea, and so on? But one thing I must emphasize is that the Tokyo Tribunal was hardly ever mentioned. It was totally outside of the debate. It was not relevant. In the end, both the House of Councillors and of the Representatives unanimously approved the accession bill and the act on the cooperation with the ICC. Now I conclude with my remarks on the impact of the Tokyo Tribunal on the Japanese accession to the ICC. As I have just said, that during the deliberation at the Diet, Tokyo Tribunal was hardly ever mentioned. Then, if we were asked whether there was any impact of the Tokyo Tribunal on the Japanese accession, the answer should be no. However, if we put the question in perspective, arguably, through the question of Yuji Hosei, the experience of the Tokyo Tribunal implicitly had an impact. In other words, it is not the specific findings or the reasoning of the judges of the Tokyo Tribunal, but rather the very fact that the Japanese leaders were tried in the name of international community for their decision to wage a war was indirectly played a role. I highlight implicitly and indirectly because from the viewpoint of law, it is difficult to treat the judgment of the Tokyo Tribunal as precedent. Precedent, I mean, in a legal sense, with binding force to some extent. Of course, as the presentation of the distinguished judges have shown, that its jurisprudence provides some source of law. But there is a fundamental difference between the Tokyo Tribunal and the ICC in terms of nature of jurisdiction. That is, a military jurisdiction under occupation in case of the Tokyo Tribunal, and international criminal jurisdiction established by the consent of the state parties in the case of the ICC, and conceptually, well, for the lawyers at least, they should be distinguished. Well, yesterday, Professor Austen described 3 categories of the attitude towards towards this question, and he described a little, definitely not, and yes. So I must say I belong to definitely not school, and another question raised yesterday, and why Japanese lawyers are so indifferent? I'm a little puzzled why this would be so difficult to understand. I mean, would you like to be tried at the Tokyo Tribunal? I mean, court like Tokyo Tribunal. I mean, Tokyo Tribunal is about us, about our, I'm not related to any defendants, but it's about our fathers, our grandfathers, or great uncles. It's our problem. So this kind of sentiment is very difficult to explain, but this can be one answer. And I would like to emphasize that our indifference should not be interpreted that we are indifferent to the war responsibility of Japan. Japan did a horrible thing, and no one denies that except for extreme people. However, the forms of accountability is not solely limited to a criminal trial. As most of you know, in transitional justice discourse, there are various ways to address the past and take responsibility. In case of Japan too, for example, yes, we had international trial, and we use compensation, and to us, compensation has been very important, although Professor Serafim from the previous panel might disagree. But another thing is, again, it might sound strange to you, but our emperor keeps reminding us that there was war which inflicted so much pain and suffering to many, not just Japanese. Even today, he constantly reminds us. Anyway, lastly, I would like to conclude with this remark, is that when you go to the class of criminal law, and one of the first things you learn is the purpose of criminal sanction, punishment. And roughly there are 2, retribution and deterrence, prevention. If the purpose of criminal sanction is not only retribution, but also a deterrence or prevention, the Tokyo Tribunal fulfilled the purpose. The Tokyo Tribunal was about the crime against peace, and indeed, Japan has never committed itself to armed conflict in these 70 years. So I humbly submit this aspect is worth being acknowledged at the occasion to commemorate or celebrate the Tokyo Tribunal. Thank you very much.
Well, thank you, Professor Ko, for that fascinating presentation, and it certainly is reminded of, I think it was an earlier panelist who talked about the need to bring Japan into this discussion because it was omitted in so much of what happened in Tokyo, and the impact that we see with Article 9 of the Constitution, which obviously swears off foreign military activities to a substantial extent. I'm sort of curious from a political standpoint now. I know back in the 50s, Kishi, the suspected but never charged Class A war criminal, when he was prime minister, he tried hard to change Article 9, failed. I know that his grandson, Prime Minister Abe, through sort of a reconstruction or reinterpretation of Article 9, is to some extent trying to make Japan's sort of foreign engagement more possible. Where is that debate now, particularly with Abe's popularity at a low ebb? Will there be sort of a reinterpretation, or is it something that will continue in Japan to be reluctant as a result of Tokyo, as a result of the failed war, to engage militarily in the rest of the world?
Well, there has been the amendment to the Constitution has been an agenda in the Diet. I mean, there has been discussion in the parties, and now, as you said, Prime Minister Abe's popularity is slowing down. So I don't think we will have an amendment procedure in a year or so. But the discussion is ongoing, and I think it should be noted that it's not that we say, "Oh, let's go to the war again." No. I mean, I don't think we're going to change at least the first paragraph. But presently, as I read out, paragraph 2 says we can't have any force, but we have force. I mean, self-defense force. So the legal status of this legal self-defense force is so ambiguous. Yes, unclear. So it's something that many people want to change, but not change to make Japan become more aggressive toward armed conflict. No, it's just Japanese sentiment is so anti-war even today.
That I know in one of the earlier panels they said don't discuss politics, just process. But I think we're able in the last panel to get into a few political or policy issues. So we're going to finish just at 1700. We're not going to go long just because we started late. So and if we can finish sooner, that's fine. But we want to hear out all the questions. Yes, sir.
Sorry to be the first one again to take the mic. I've just a very brief question to Judge Lee and then one to Professor Ko. Judge Liu, I'm sorry. You made very insightful comments on the notion of conspiracy as a mode of liability as opposed to being an inchoate crime and the discussions in Tokyo going on. And if I understood you correctly, you also mentioned that the ICTY, or perhaps in a broader sense, the ad hoc tribunals carried this notion on into the concept of JCE, Joint Criminal Enterprise. Is this what you were trying to point out? Actually, to be honest, I never really understood this part. I never really fully understood what JCE is about anyway, but when this was developed for the first time in the Tadic case, perhaps, I don't know if it was especially Kasese who was influencing, but anyway, as is widely known, the Tokyo trial was, or the Tokyo judgment, the IMTFE judgment was in a kind of rather vague manner referred to as a basis for this supposedly for this new notion supposedly existing under customary international law. And I would be very interested to know what elements actually were taken over from conspiracy in Tokyo to the ad hoc tribunal's JCE jurisprudence, if any. Thank you. And the other one is a question to Professor Ko, thank you very much for also these very, this overview of the current discussion in Japan. And I entirely agree with you in relation to the major factors which led to the accession of Japan to the Rome Treaty. And I just have a question out of curiosity. You mentioned that before the accession, the Yuji Hosei was enacted in 2004 under the Koizumi administration, and why did not, or to put it a little bit politer, wasn't there any discussion of with regards to ratifying the Genocide Convention either in 2004, back in 2004, when Japan ratified the 2 additional protocols, or at the latest in 2007, when, in any case, it accepted the notion of genocide by acceding to the Rome Statute. So even now, as is also widely known, Japan is not a member of the Genocide Convention, and in my personal opinion, maybe something which could be an influential factor in this regard is the fact that the convention could be construed as imposing an obligation on states to enact national legislation with regards to the substantial crime of genocide. And this might be something which, given the discussions in 2007, the Japanese government tries to avoid, or even tries to avoid even now. And just a little footnote in this regard. As you of course know, in last year, the Japanese Parliament adopted a new concept of conspiracy in its national criminal law, and would you interpret this as, in a very broad sense, as Japan now accepting the conspiracy charges which were made in Tokyo? And we of course all know that one of the biggest discussions, especially as it was done by the defense lawyers, was circulating around this conspiracy element of being incompatible with the Japanese domestic criminal law system, but now it just entered last year, the Japanese domestic legislation. Just your thoughts on this, on these 2 aspects. Thank you.
Other questions? Yes.
Thank you. Yesterday I asked Professor Austin why does the Japanese legal community is not taking an interest in or try to take ownership of the legacy of the Tokyo trial. And I see Professor Ko was trying to address this question. I appreciate that. But my question was really not whether or not you would like to have been tried at the Tokyo War Crimes trial. So your answer is somewhat, appears to me as somewhat curious. Let me rephrase my question. Would you regard the Tokyo trial as a useful source to draw upon to think about the substantive law of international criminal law, or also some procedural aspects of the international criminal law? And I may also phrase it this way: would you look at the documents, the transcripts of the court proceedings, including the court exhibits submitted at the Tokyo trial, to think about the factual dimension of the Japanese conduct of war? Yesterday, Professor Diane Oren-Licker pointed out that while incomplete, there was a lot of evidence on sexual violence introduced at the Tokyo War Crimes trial, including so-called comfort women, which is now understood as a form of sexual servitude or sexual slavery. And however incomplete the picture of sexual violence reconstructed at the Tokyo trial, it's now considered as that. My understanding that historians and human rights scholars alike consider this as a rather valuable source of information. So I would like to ask Professor Ko to address this question once again. Do you find this the Tokyo trial as a useful source to think about both the legal issues, procedural, and factual aspects of the Japanese conduct of war, including the issues of comfort women as a form of sexual slavery? Thank you.
Professor Tatani, we have a third question to put. Yes, Bill Pace.
Thank you. And in a way, I wish Professor Koh's comments could have come earlier in the first day or something. I think it's quite interesting to have today, so thank you very much. But I want to take advantage of Judge Liu. Is there any lessons from either the Tokyo tribunals and other tribunals that will help us with how the Chinese government on the Security Council will deal with accountability for these worst crimes in international law, that you would be able to give us some direction? I guess the other side of that is, where do you think the Chinese government will be in terms of ratifying the Rome Statute in the next 10 or so years?
So once
and you
we
may
break
want to
the
have
rule-
a drink instead of a discussion night here.
Once we break the rule against politics, then we all speak for our countries. So anyway, we'll, I think, take these three questions. We have Professor Austin's question both to Judge Liu on conspiracy and JCE, but also to Professor Koh on genocide and conspiracy, et cetera, and what the, what the Japanese position is, and why they didn't, why the Diet didn't move forward on the Genocide Convention, and whether the attitude on conspiracy has changed. So we've got that question first, and I guess we might as well, while people are speaking, answer each of the questions that may be relevant to them, because we've only got 15 minutes left. We also have Professor Tatani's questions, basically about the useful work that was done by the Tokyo Tribunal and its durability and usefulness to the ad hoc tribunals and to the ICC, both on a legal and factual basis, including the evidence, the strong evidence that was presented on sexual violence and slavery, even though that might not have been reflected in the judgment. That's part of the record. And then we've got Bill Pace's question, which goes to some extent what the position of a permanent member of the Security Council might have regarding the ICC and its involvement in situations in the future. So let's I guess we'll start here. Well, let's go the way we began. Judge Liu, if you want to answer whichever part of those questions you want to take.
Let me answer it all together. I think that saves much more time. Thank you very much for your question concerning with the joint criminal enterprises and conspiracy, which is a very, complicated issue. And frankly speaking, at the very beginning of the ICTY, all the judges debated furiously, about, whether it's the mode of the liability or the inchoate crimes. Because, as I said in my presentation, in the Tokyo trials, I believe that, the positions of the prosecutor is crystal clear. That is an inchoate crime. Maybe it's from the terminology of the common law legal system, if I may say that. But however, in the judgment of the Tokyo Tribunal, it's not that crystal clear. I don't know the exact reason, but maybe there are some debates between the two, different legal systems among the judges on this issue. And also, in the Nuremberg trials, all those people who convicted for the conspiracies, but also convicted with the subsequent crimes occurred, which gave the readers an impression that it might be a mode of the liability. Actually, those two modes of the liabilities, joint criminal enterprise and conspiracy, share many common features. The first, it also requires the plurality of the people. I mean, more than two peoples, there. Secondly, there must be a meeting of the criminal minds. All those people, thinking together, to do something terrible, to kill, or genocide, something. The thirdly is that, there must be a kind of plan there, the common desire there, which has maybe not, written down, but it's already there. Everybody has, agreed to that of the scheme. But as I said, it's one of inchoate crimes. The other is the mode of liability. So in the Talich case, in the first case, they used, they divided, the original concept of conspiracy. One is to the direction of the joint criminal enterprise, which is a mode of the liability. The other is the inchoate crime. As I mentioned before, that inchoate crime is only applicable to the most serious crimes, because some judges even have serious doubts on whether you should punish the thought in somebody's mind, because sometimes there's no concrete plan at all on that issue. And I hope I answered this question to you. And as for the China's position, I'm very sorry to say I'm not in the position to speak for Chinese government. I believe that the behavior of our country, especially in the Security Council, depends on the political wills and the political needs, as well as whether this country will join the ICC or not. But this is from the top levels of the decision makers. But I'm very glad to say there's a great demand in China, for the international justice, on that. In almost every universities, they have the classes of the international law, especially in the international criminal law on that. And we have the moot court competitions, and so there's a great awareness among the lower part. So the approach is that, maybe, it will form certain kind of momentum from the bottom-up, approach, rather than the top-down approach. I hope I answered your question. Thank you very much.
And if I might add just a bit, as someone who was very active as an observer, as a non-party, as the representative of a non-party to the ICC, representing the U.S. In the Assembly of States Parties as an observer, and not being part of the ICC, but looking for ways that we could cooperate. I know in my meetings with Chinese diplomats, both in Beijing and elsewhere, they were also very active as observers and always participants in the sessions, and very interested in international justice and what the possibilities were. So I think there was a much more open door there than, frankly, we ran into in discussions with the Russians. So I hope that China will move forward, and as at least the U.S. did in the last administration, to becoming a strong supporter of the ICC, at least on a case-by-case basis. Let me now turn it to Judge Osaki. I'm not sure we had a specific question, but if you'd like to respond particularly to Professor Tatani's question.
Thank you very much. Actually, nobody asked me questions, and I feel a bit lonely, so I'd like to intervene so long to answer to some of the questions to the extent that it relates to my topic. I would like to start with Professor Austin's question about conspiracy. I think what you mentioned about the conspiracy dispute in Japan recently is the United Nations Convention Against Organized Crime, Article 5. Is that what you mean, I guess? Yeah. And I think the conspiracy in that convention is quite different from conspiracy in Tokyo Tribunal. And the Tokyo Tribunal conspiracy's problem is that, as Judge you just mentioned, I really cannot understand what it means. While Antok Convention, because it is modern convention, it is very, very meticulously defined conspiracy type of crime. So I think it's a quite separate question. And with regards to the Professor Totani's question, whether we accept a legacy,
It's not accept or not, but whether you regard the Tokyo trial as a useful resource
to think about substantive issues of the law or procedural aspects of the law on the one hand, and on the other, to think about the Japanese conduct, to think about the factual dimension of the war, namely the Japanese conduct of the war during World War II, and especially with regard to war crimes, sexual violence, things like that.
Okay, so maybe I misunderstood your question. Of course, it is very useful resources, but useful resources meaning both positive and negative way. Yeah. So procedurally speaking, it's very difficult for any contemporary lawyer to accept military commission type of criminal procedure rule, and I think that's it. You know, we are now firmly established human rights standards. And as for substantive law, of course there are sexual violence, but we have already sexual violence. Criminal code against various types of sexual violence. And maybe with regard to the mode of liability, for example, whether, Japan can criminalize command responsibility, that could be a very, very interesting question. And I don't see any substantive discussion about this in Japan.
Yield your time
yeah, but
maybe
well,
Who can respond on this question
because
of progress?
I really not familiar with the current Japanese discussion about how to criminalize this kind of mode of liability. So far as I know that there's not yet any criminalization, and but one thing I would like to say is there is a German criminal code which criminalized this mode of liability, which could be quite interesting from Japanese perspective, because Japanese criminal code, in general part of criminal law, is very German-like. So it could be one aspect which we may consider. And as for the question about Security Council, from the perspective of ICC, what I can say is that, okay, Security Council has power to refer the case, but if once they refer the case to us, please take follow-up responsibilities as well. And that's all what I want to say. Thank you very much.
Professor Ko?
Thank you very much for your questions. And first question by Professor Austin. I think not just conspiracy, but every time the government tries to expand the scope of criminal law, substantive law, they meet the resistance, particularly from you guys, I mean criminal law professors. So, because it gives, I think to them, it gives more power to the government. And we had a history of government violating human rights, like pre-war Japan. So, it's more like, it's almost like allergic to it. They're allergic to any discussion expanding the scope. So, but I don't know, maybe young criminal law professors or lawyers may have different attitude in the future, but so far, I don't think that adopting the legislation last year would really open the way to accession to the Genocide Convention. It's just my own personal impression, but that's what I think. And as to Professor Totani's question, I fully agree with what Judge Ozaki said. And of course, Tokyo Tribunal was very important, and it's such an extraordinary experience. And but everybody has, it's full of episodes. Everybody has something to say about it. Like my mother, she went to see the proceeding, she said, when she was 20 years old or something. So it was a big event to many Japanese people at that time. And you ask for the lawyers, right? But I think, yes, as Judge Ozaki said, and I said in my presentation, it was military jurisdiction. It was not criminal jurisdiction. So I for me, it's very important to distinguish two different jurisdictions. So it's not that I say there is no legal importance in the Tokyo Tribunal, but we have to work hard to really articulate the lesson or rules that we can use because the nature of the jurisdiction.
What's your opinion on the treatment of the evidence of sexual violence at the Tokyo trial, especially with regards to comfort women?
I am not specialist on the comfort women issue, so I'm not sure if I can explain it well, but and I'm not sure if I can have many supporters here. But often when I listen to the victims of war discourse, the most marginalized people are the Japanese women. I mean, Japanese women, they didn't have a right to vote before the war, so they didn't participate in a political decision of the Japanese government. And their husbands were drafted and sons were drafted, and most of the time they came back in a box as bones. And many Japanese women were supposedly, it's only rumor, but they were raped when was escaping from northern China. But of course, without international commission of inquiry, we can never address that issue. And so, so I am so sorry for the women who suffered, and it's not good to compare who suffered more severely. But I think the Tokyo Tribunal was about the crime against peace, because there cannot, how can I say, war is inhuman, and it's difficult to have human activity during the war. So the best thing is that you just don't go to the war. And that's the lesson I think we learned. So I don't really have a strong opinion of the specific question of the treatment of women issue at the Tokyo Tribunal, but that's how I feel.
Form of sexual. I'm sorry, but you do have problem referring to the comfort women issues as a form of sexual servitude. Isn't that correct? Or sexual slavery, to be exact.
I thank Professor Tatani for her question, and I think this is a discussion that we can carry on for a long time. I do want to make the observation, though, that as we deal with these questions, and particularly this one, I'm one who wishes that we would have had a judgment in the Tokyo Tribunal on the issue specifically, and it's one of the important roles, and that it's not the only role, but in these international criminal tribunals, certainly what happened here at Nuremberg, I think, made the denial of the Holocaust fundamentally impossible. And people who were there testified, and the commandant of Auschwitz, who was a defense witness, testified, even said 3 million had died there, more than actually had been killed. And so having these proceedings and having clear judgments and decisions, they may not be well liked or accepted by people, but I do think that a lesson in this continued issue over the comfort women, I think, does point out, frankly, a flaw in the approach in Tokyo, that we didn't have a count and we didn't have a conviction on that issue. Now, whether that was available at the time in 1945, given the state of the Geneva Conventions and everything else, is also a debatable issue, but I think it underlines the importance so we don't end up with a continued political disputes between governments about whether something happened or didn't happen. We've got a record in a neutral court, which is the ideal now with the ICC, that settles that issue to really, fundamentally beyond a reasonable doubt. So with that final comment, I will now, I think, go with our speakers. Professor Safferling will be next. Let's thank the panel for their discussion today. Thank you.